There's a scene in Laura Poitras's documentary, Citizen 4, in which Edward Snowden, who's holed up in a hotel room in Hong Kong, pulls a blanket over his head as he's logging onto his laptop. He's worried that the National Security Agency, or who knows, perhaps some other intelligence agency, has managed to fit his room with hidden cameras, and he wants to keep the spies from learning his password. The same scene, slightly fictionalized, appears in the film that Oliver Stone released just a few weeks ago. It draws a vivid contrast, I think, between the whistleblower, human, paranoid, fugitive, vulnerable, literally hiding under a blanket, with the surveillance agencies, which are mysterious, powerful, and seemingly everywhere. I think the scene also captures an essential point about Snowden's story. Even as Snowden fights to expose the government's secrets, he's desperate to protect his own. And in this narrow respect, we might think of the NSA and Snowden as mirror images of one another. In fact, people sometimes joke that the agency's the agency's acronym, NSA, stands for No Such Agency. And the joke is an acknowledgement, it's not a very funny joke, but it's an acknowledgement that the agency's power depends on its ability to keep its secrets and not just on its ability to learn everybody else's. And that's probably more true now, I think, in the digital age than it has ever been before. The digital age, our age, will give rise to many novel and vexing questions relating to the scope and substance of First Amendment freedoms. One reason for that, as President Bollinger just mentioned, is that the Supreme Court's seminal cases relating to the freedoms of speech and the press, the cases that shape our public discourse and public spaces today, were decided half a century ago. They were decided before the advent of the internet, the rise of technology giants like Microsoft and Apple, the invention of the search engine, the arrival on the world stage of transnational transparency activists like Julian Assange and WikiLeaks, before the development of end-to-end encryption, and before the emergence of social media. Some of the factual assumptions that underlie seemingly settled First Amendment precedents may no longer be sound. At the very least, over the next decade or two, the courts will have to determine whether and how to apply those old precedents to very different contexts. What I'd like to propose here is that the questions about surveillance, official secrecy, and individual privacy, the questions that Snowden's story provokes, will be among the most significant that the First Amendment will have to answer. What is the government entitled to know about us, and what are we entitled to know about it? Here in the United States, the post-Snowden debate has taken place against the backdrop of the Fourth Amendment's protection against unreasonable searches and seizures. But questions relating to surveillance, secrecy, and privacy have long been the province of the First Amendment, too. The First Amendment, for example, has long been understood to limit the scope of the government's surveillance power. It's long been understood to give the public, in certain narrow contexts, a right of access to information the government would prefer to withhold. Whistleblowers have sometimes argued that the First Amendment limits the government's power to punish them for disclosing official secrets. The First Amendment had something to say about surveillance, secrecy, and privacy before the era of smartphones and social media. I'd like to consider, or at least begin to consider, what the First Amendment might have to say about those topics, and what it should have to say about those topics, now that the digital age has arrived. What we learned from the Snowden disclosures is that the signals intelligence agencies have become immensely powerful, that their surveillance capabilities have been directed increasingly towards us, and that the institutions that were meant to protect individual rights against the encroachment of government surveillance power have failed quite spectacularly. Thanks to advances in technology and investments in physical infrastructure, signals intelligence agencies like the NSA can now continuously collect staggering amounts of data. They can retain it indefinitely, they can analyze it with powerful tools, and they can identify patterns and connections nearly instantaneously. The NSA's data storage facility in Bluffdale, Utah, is 5 times the size of the US Capitol. The agency, which is estimated to have some 40,000 employees, is said to be the largest employer of mathematicians in the world. A now infamous NSA PowerPoint slide published by The Guardian is titled New Collection Posture. It states forthrightly that the NSA's aim is to collect it all. Our intelligence agencies haven't yet managed to achieve that goal, but they've come unnervingly close. Of course, they couldn't have done this on their own. They're parasitic on the private corporations that track what we buy, what we read, who we talk to, where we go. The problem, as we're continually reminded, is that virtually everything we do in the world leaves a digital trace, and multinational corporations lay claim to those traces. The phone in your pocket is a surveillance device that permits the tracking of your movements, communications, purchases, and associations. By examining your use of social media and search engines, an analyst can readily deduce your intellectual interests, your religious views, your politics, your medical history, your intimate partners. There's a sense in which a person who knows all of that about you knows you better than you know yourself. Courts have begun to tackle some implications of these new technologies from the perspective of privacy and the Fourth Amendment. In a recent case concerning the government's installation of a GPS device on a criminal suspect's car, Justice Sonia Sotomayor considered the conclusions that police might draw from the record of a person's location over a period of 28 days. She wrote, "A precise, comprehensive record of a person's public movements reflects a wealth of detail about her familial, political, professional, religious, and sexual associations. From seemingly innocuous data, some of it readily available to the public, the government can learn the kinds of things that most of us would have recorded, if at all, only in our diaries or in letters to our closest friends. The collection and retention of all that information is likely to have far-reaching implications for the freedoms of speech, assembly, and the press, though the change in our behavior may be subtle and gradual. A person who believes she's being monitored may hesitate before participating in a political demonstration, visiting a website the government is thought to disfavor, or following an unpopular political group on social media. Someone who's lost confidence in the promise of anonymity may hesitate before calling a reporter. A teenager who believes a record is being made of her activity on the web may hesitate before using a search engine to explore issues of sexuality. People who know they're being surveilled will modify their behavior in response to that surveillance. Each of the hesitations may be innocuous or insignificant in itself, but the accumulation of them will amount to a transformation in the way we engage with the world and with each other. Perhaps more consequential than the fact that everything is collected is the fact that nothing is deleted. It's one thing to have to worry that anything you do online may be tracked by a corporation or government. It's another to have to worry about the possibility that your data may be exposed, whether maliciously or inadvertently, 10 or 20 years from now. There are no second acts in lives lived on the internet, as F. Scott Fitzgerald might have said had he been given the chance to sign up for an Ashley Madison account. The personal and political and intellectual risks you take today and the mistakes you make as a result will be attached to you in one way or another for the rest of your life. In an effort to address a related problem, some privacy activists have advocated a right to be forgotten, a right to compel search engines and perhaps others to unpublish or suppress information that's outdated, inaccurate, or simply embarrassing. I'm skeptical of that effort, but in a world in which the delete key is a false promise, it's easy to understand why so many find the proposal appealing. One danger here is that the fear of surveillance will have a homogenizing effect on us, that it'll lead to a tempering of curiosity, to a tentativeness that infects the political and the personal, and even to what Bernard Harcourt has called the mortification of the self, a transformation that takes place when a person structures her life so that she has nothing to hide. In a world in which everything is tracked, conformity has a gravitational pull. Sometimes surveillance requires conformity. There was a story in the Times just a few days ago, I'm sure some of you saw it, about a civil servant who sued the French government over a regulation that bans smiling in passport photos. The law is necessary, the government says, because facial recognition software functions best when facial expressions are neutral. An instance of surveillance prohibiting expression, quite literally. Maybe that's a trivial thing, barring people from smiling for passport photos. But it's still a surrender of human particularity to the homogeneity required by the surveillance state. And there are less trivial examples. Over the last couple of years, the FBI has proposed that designers of computer hardware and software be required to build their systems in such a way as to facilitate government surveillance. Their products can be diverse in many different ways, the FBI says, but in this particular way, they must all be the same. Social activity must accommodate itself to the overriding requirements of government surveillance. I think it's worth thinking about all of that through a First Amendment lens. In the early 1960s, the Supreme Court barred a congressional committee from requiring the NAACP to disclose information about its membership. It reasoned that compelled disclosure of membership information would have a chilling effect on the freedoms of expression and association. A decade before that, the court heard the case of Edward Roomley, a bookseller who had declined to comply with a congressional subpoena, commanding him to divulge the names of those who had purchased his books. The court held that the subpoena was unenforceable, and in a somewhat overwrought concurrence, Justice William Douglas reflected at length on the dissuasive effect that unchecked surveillance would have on the exercise of First Amendment rights. Requiring publishers to disclose the identity of those who bought their books, he wrote, would be, quote, the beginning of surveillance of the press. If the government could compel booksellers to disclose the identity of book purchasers, the specter of a government agent will look over the shoulder of everybody who reads. The purchase of a book or pamphlet today may result in a subpoena tomorrow. Fear of criticism will go with every person into the bookstall. So I think that Justice Douglas's dystopia probably seemed far-fetched at the time. But I think that his fears are harder to dismiss today. During the demonstrations that preceded the 2014 revolution in the Ukraine, protesters attending a pro-democracy demonstration in Kiev received this text message. Dear subscriber, you're registered as a participant in a mass riot. The source was unknown, but I think the message was clear. Think twice, we're keeping track. What you're doing isn't a secret from us. A recent study by PEN American Center, the writers' organization, found that 1 in 6 writers had curbed their content out of a fear of surveillance. The writers who responded to the survey were not only overwhelmingly worried about government surveillance, but engaging in self-censorship as a result. A study published earlier this year in the Berkeley Technology Law Journal found that Wikipedia pages that included terms associated with national security and terrorism were visited 20% less often in the months after the first Snowden disclosures than in the months before. The study's author wrote that his findings were consistent with, quote, a sharp, immediate chilling effect and possibly with, quote, a lasting impact on total page views. 2 years ago, researchers for Human Rights Watch and the ACLU interviewed journalists and editors at American media organizations about the impact of government surveillance on their professional activities. And the interviewees included journalists and editors from the New York Times, the Wall Street Journal, the Washington Post, the AP. Collectively, they had more than a dozen Pulitzer Prizes between them. The journalists reported that government surveillance and the related crackdown on unregulated contact between officials and the press had combined to, quote, constrict the flow of information concerning government activity. Surveillance had made it more difficult for sources to remain anonymous in their dealings with the press, and the fear of surveillance was dissuading would-be sources from contacting reporters and making reporters' existing sources more reticent. Sources were more reluctant to speak even about matters that were unclassified, but the chilling effect was felt most acutely by journalists investigating issues relating to national security, intelligence, and law enforcement. There's something a little bit paradoxical in all of that. New technology has given us new ways of communicating, new ways of understanding the world. So many more possibilities are open to us now than were open to us only a generation ago. And yet, as the possibilities are expanding, our willingness to explore them may be contracting. The same technology that's opening new worlds to us may be rendering us less capable of discovering them. Surveillance by governments and corporations may be making us risk-averse and fearful. At least at the margin, we're choosing not to say things we'd otherwise have said, not to investigate ideas we'd otherwise have investigated, not to report stories we'd otherwise have reported. There's no censorship involved here, except what R.E.A. Nair once called the soft censorship of surveillance. Congress has enacted no law directly restraining the freedom of speech or the press. But if the freedoms of speech and the press are to remain vital and meaningful in the digital age, if they are to survive the digital age, the next generation of First Amendment cases will have to grapple with the implications of surveillance. Snowden exposed the surveillance state, but he also exposed our ignorance. As alarming as the NSA's surveillance activities turned out to be, it was at least as disconcerting that we'd known so little about them. Shielded by secrecy, the government's activities had become unmoored from the democratic consent on which those activities were said to rest. Senator Ron Wyden of Oregon warned of precisely this when he said in the spring of 2011 that Americans would be stunned and angry when they learned how the government was interpreting the Patriot Act. But it wasn't until 2 years later, when the Snowden disclosures first began appearing in The Guardian and the Washington Post, that we began to understand how wide the chasm had become between what we'd authorized the government to do and what the government was actually doing. The secrecy surrounding surveillance was indicative of a broader trend. The Associated Press reported last year that the Obama administration has set a new record for denying requests under the Freedom of Information Act. Agencies took longer to turn over files when they provided any. They said more often that they couldn't find responsive documents, and they refused a record number of times to quickly process files that were especially newsworthy. Here's another measure of government secrecy. In each of the last few years, the FBI has issued thousands of national security letters, each one accompanied by a gag order, a judicially enforceable demand that the recipient not disclose the letter's contents or even existence. And here's another. The Obama administration has prosecuted more people under the 1917 Espionage Act than all previous administrations combined. Perhaps more significant, it's used the act against whistleblowers like Snowden and Chelsea Manning, collapsing the distinction between those who disclose official information to the press and those who disclose it to foreign intelligence services. By many measures, the government has become significantly more secretive. Certainly in the spheres of national security and law enforcement, the resort to secrecy seems to have become almost instinctive. When I was at the ACLU, as I was until just 3 weeks ago, I was involved in several Freedom of Information Act lawsuits relating to the CIA's use of drones to kill suspected enemies overseas. Even as senior officials selectively disclosed information about the drone campaign to the media, the CIA argued that national security considerations precluded it from confirming or denying that the campaign even existed, let alone that the agency had any role in it. When courts rejected that argument, the CIA conceded grudgingly that it had relevant records, but still insisted that national security considerations precluded it from describing the records or even saying how many there were. When the agency was forced to abandon that position, it described the records in only the most generic terms and contended that none of them could be safely released. Over a period of 5 years, we managed to win landmark legal victories from 2 federal appeals courts, but at the end of the process, the CIA hadn't released anything, not a single document. It took us 5 years and hundreds of hours of work just to arrive at the starting gate. So the surveillance state has grown, but the empire of secrecy has grown too. The government has been demanding more and more information about us, but disclosing less and less about itself. Elaine Scarry observed more than a decade ago that citizens were becoming more visible at precisely the time the government was becoming less visible. And because the government is less visible to us, our public debates are less informed. Often they revolve around personalities rather than policies. Often, especially in the spheres of national security and law enforcement, we don't have the information we need in order to evaluate government policy, let alone hold officials accountable for their decisions. The First Amendment shouldn't be indifferent to all of that. The Supreme Court has recognized that a major purpose of the First Amendment was to protect free discussion of government affairs. And from that premise, it's concluded that the freedom of the press encompasses a right to gather news. Relying on similar reasoning, it's recognized a right of access to criminal proceedings, and lower courts have recognized a right of access to civil proceedings and to certain judicial documents. The Supreme Court has rejected any, quote, narrow literal conception of the First Amendment's terms. And it said that the amendment is broad enough to encompass those rights that, while not spelled out in the amendment's text, are necessary to the enjoyment of other First Amendment rights. Perhaps in the existing case law, there's raw material from which the courts could construct a broader right of access, one that would render us less dependent on the Freedom of Information Act, an act that's failing us in so many ways. The First Amendment might also have something to say about the rights of government whistleblowers, without whose disclosures we'd know far less about American military involvement overseas and surveillance policies here at home. Chelsea Manning was sentenced to 35 years imprisonment for violation of the Espionage Act, but she's appealing her sentence. My former colleagues at the ACLU recently filed a brief arguing that the act violates the First Amendment unless it's read to require a balancing of the government's interest in secrecy against the public interest in disclosures. At a time in which the President, the Director of National Intelligence, the CIA Director, and many other government officials agree that too much is classified, a criminal statute that fails to distinguish information justifiably kept secret from information that should never have been withheld in the first place should be regarded as constitutionally suspect at the very least. Let me mention one last set of questions that I think will be central to the next generation of First Amendment cases. And these questions are, in some ways, the counterparts to the ones that I raised at the beginning of this talk. All over the world, from Tehran to Kiev to Baltimore, protesters who would otherwise have been isolated from one another have relied on social media to organize, to persuade others to join their causes, to coordinate their actions, and to bring their complaints to public attention. After the 2009 election in Iran, it was cell phone video depicting the paramilitary killing of Neda Agha Sultan that galvanized the opposition. Here in the United States, bystanders' cell phone videos documenting the killings of Eric Garner, Alton Sterling, Philando Castile, and so many others have sparked outrage over police violence and fueled the Black Lives Matter movement. Apparently inspired by American racial justice advocates, activists in Nigeria, the Ivory Coast, Guinea, and elsewhere in West Africa have begun to use cell phone video as a way of calling attention to abuses by their own governments. Little by little, the New York Times reported 2 weeks ago, many of the videos shared on social media are chipping away at impunity, and in some cases drawing widespread attention to problems that the authorities are finding hard to ignore. And this, I think, is a crucial point. Governments don't have a monopoly on new technology, or even on new surveillance technology. There's Big Brother, but there's also a proliferation of little brothers. The digital revolution has enabled an unprecedented expansion of the government's surveillance capabilities, but it's also given ordinary citizens new means of holding the powerful accountable. We should expect the next generation of First Amendment cases to grapple with the expansion of government surveillance power, but also with the partial democratization of it. Last week, Alex Younger, the chief of MI6, the British analog to the CIA, gave a rare public speech in which he acknowledged that the information revolution had, quote, fundamentally changed his agency's operating environment. The digital world is a very interesting combination, he said, a golden opportunity, but also an existential threat. MI6 finds it easier to collect secrets, but more difficult to protect its own. The scope of the individual right to conduct what some people have called surveillance will depend in part on First Amendment cases yet to be litigated. Federal appeals courts have recognized a First Amendment right to film police activity in public places. A district court in Philadelphia recently disagreed, but the question will soon be presented to another appeals court. Even if this decision is reversed, how far does the First Amendment right to record and broadcast government activity extend? But let me return, finally, to the image I began with, of Snowden guarding his own secrets as he tries to carry on what we might describe as a radical or particularly radical form of surveillance. The image has little in common with the ones we most often associate with the First Amendment. It doesn't involve a printing press or a prior restraint. But the threats to free speech today are different from the ones that confronted Peter Zenger almost 300 years ago when his New York weekly journal skewered New York's royal governor. And they're different from the threats that confronted the New York Times almost 50 years ago when it published the Pentagon Papers. On the face of it, Richard Kluger observes in his biography of Zenger, press freedom in America has attained a degree of vigor that would have been as unimaginable to Peter Zenger and his contemporaries as today's man-made vehicles traveling to the edge of our solar system. That's probably true on the face of it. But as Kluger also observes, challenges to First Amendment freedoms take many forms, and subtle and indirect threats can sometimes be more perilous than overt and direct ones. Kluger himself warns of, quote, governments in garrison states and open societies alike that are stealthily wielding sophisticated tools of surveillance in the name of national security, no matter the wholesale loss of personal privacy and dignity. Few images are likely to capture the most serious threats to the freedoms of speech and the press today as neatly as the image of Snowden facing down a surveillance agency that has hoovered up so many of our secrets while so jealously guarding its own. Thanks again, President Bollinger and Dean Cole. I'm happy to take questions. Yeah.
Let you recover. Thank you very much for coming to speak with us tonight. My question is really around how this conversation moves from sort of the academy to the masses. So, I think that in this building, we spend a lot of time thinking about the issues that you've highlighted tonight. And I think that my concern is more about how other people may be thinking about these issues. And so when you poll people about privacy and whether they're concerned about it, they say, absolutely, I'm very concerned. And then you say, if you tell me what your Wi-Fi signal is and I can track you in my store, I'll give you a coupon. And they say, a coupon? So my question is it sufficient for this conversation to be taking place, in universities and within organizations like yours? Or is it important to have other people care about it in the same way? And if it is important, how do you start to do that?
So I don't think it's sufficient to have this conversation in the academy for precisely the reason you mentioned. I don't think that we have the power here to change the policies. We have the power here on our own to change the kinds of policies that I was talking about. I certainly don't have the power to change the policies of the big tech companies. But I do think that there is a growing recognition that those trades that we make daily or even hourly, giving away a little piece of our privacy in return for some functionality, I think that there's a growing awareness of the long-term costs of those trades. And there was a story just a few hours ago about Yahoo scanning all incoming emails under a directive from the NSA. This is something that Reuters disclosed just a few hours ago. And I noticed that on Twitter, one of the responses one sort of common response was, you should never have had a Yahoo account in the first place, but if you have one, now is the time to close it. And I think that may be true, but I think it's interesting that people seem now to think that they should respond first to events like this, and that they can respond by moving their account from Yahoo to Google or to some other corporation. And I think that there is increasingly a competition between the technology companies for customers or subscribers who care about privacy. And they market themselves in part by the actions they're taking to protect their customers' privacy. I saw that in Twitter's response, so somebody asked Twitter, did you get a similar order to the one that Yahoo got? And Twitter's response was a bunch of mostly jumbled words, but that ended with, but look at this case in California where we're suing to vindicate our customers' privacy rights. So I think that the companies now get it. They get it that it matters to at least some substantial fraction of their customers or subscribers that they are protecting privacy. Now, there's a further link that I'm not sure people are yet making between the kinds of surveillance that I was talking about and the kind of surveillance that was revealed today of Yahoo and First Amendment freedoms, right? I think that people have started to get that there's a privacy cost to these trade-offs. I'm not sure how much people have thought about the cost in the freedoms of expression and freedom of association. I'm not sure how far people have gone down that path. But that's part of why I decided to talk about this tonight, because I thought it might be useful to try to reframe what has been largely a debate about privacy as one about freedoms of expression and association as well.
Thank you.
Hi. We know that in the 1950s and 60s, the FBI under J. Edgar Hoover virtually captured the White House and the Congress because of its secret files. So Hoover could blackmail anybody, and did. Now it seems like the intelligence community, 16, 17 agencies, 100,000 plus people, has captured the Congress and the president. It's striking that Obama could not contest the intelligence community's vision of what is necessary. So you have a presidential daily briefing every morning, Director of National Intelligence. It's very great feeling to be at the center of all secrets on the planet Earth and beyond. So every president, it seems to me, in the future, including Hillary Clinton and anybody else, is going to be susceptible to the capture by the intelligence community. What can somebody in the White House, what can the National Security Council, what can anybody who cares about this issue do to help support a new president who's going to be coming into office in a few months?
There's something I think very important in what you said, which is, and I'm not sure that people appreciate to what extent the system right now depends on the good faith of the people in charge. I think that there is the impression that there is a very robust set of regulations that constrains the power of the intelligence community, the power of the surveillance agencies. I don't personally think that the regulations are as robust as they're often said to be. And most of these regulations are invisible to us, right? The ones we can see because of the Snowden disclosures or similar disclosures, or to some extent the government has disclosed some of this information in response to the Snowden disclosures. But it's the tip of an iceberg, most of which we have no visibility into. And I think that one thing that the next president, and I don't think it's a job only of the president, but also of Congress and the courts. One thing that I think is really crucial is creating a system that is less dependent on the good faith of the people in charge, and that is more dependent on institutions whose whose effectiveness is visible to the public, whose effectiveness and authority is visible to the public. I don't think that's a fair description of the system we have right now, but there's no reason why we couldn't have that system if the president and Congress wanted to put it in place.
Just one follow-up, and I'll sit down.
Yeah.
Maybe Mr. Cole is the one who really needs to speak about this. What is the responsibility of the media to help wrest away power over these decisions from the intelligence community and return them to the executive where they belong constitutionally?
Do you want to address that? Okay, all right. Well, we can save that for the reception.
Hi, good evening, Mr. Jaffer. Thank you again for coming. So it seems that in order to recoup some of our First Amendment losses, we need a culture that appreciates those rights more, open inquiry, and everything like you mentioned. So to that end, do you think that safe spaces and other areas of restricted speech are conducive to free speech or anathema to them? Thank you.
You know, I've only been on campus for 3 weeks, and I'm wary of wading into things that I don't fully understand. You know, I'm a free speech advocate, and I come at these questions from that perspective. But I don't want to assume that my first reaction to these kinds of proposals is necessarily the right one. So come back to me in 3 months or 6 months.
Apparently, I'm going to be the last question. So one thing that I had in mind when I first came, when I saw the invitation to this lecture, is how conversations around online harassment and stuff, where you have people who are virtually anonymous and stuff, harassing and causing great harm to people, would change because of the digital age and what First Amendment challenges does pose. So I was wondering if that's a part of the purview of.
Yeah, I mean, I think it is. Although I'll tell you, one challenge is that a lot of these questions are free speech questions, but not necessarily First Amendment questions. So, Twitter and Facebook, they're not governed by the First Amendment. They're not government actors. They're not subject to the First Amendment's limits. They care about the First Amendment to varying degrees, right? They care about the norms that have been set out by 100 years of Supreme Court cases, and I think that may be the starting point for a lot of their conversations. But at the end of the day, they can decide that they want community standards that are narrower than the First Amendment would allow in other contexts. I think one challenge for this institute for over the next few years is to figure out how we can engage that conversation that isn't ultimately a conversation about the First Amendment, but is still extremely important to free speech. And it would have been one thing, I think, if Facebook had 5% of the social media market, and maybe we wouldn't have to be so concerned about community standards that restrict speech that is protected by the First Amendment. But if Facebook is our only window into the world, if that's the way that everybody is engaged with the world, then it becomes a much bigger problem if Facebook starts drawing lines that are narrower than the First Amendment. So I don't know the answer to the question. I don't know how we should tackle that set of questions, but I think it's a hugely important set of questions, and I'm hopeful that we'll figure out an answer soon.
But it would become a First Amendment question if, let's say, I want the police to take action against an online harasser and compel the disclosure of the identity of that person through.
Yes, there are definitely situations in which the government, for example, forces Twitter or Facebook to take down an account, and that involves government action, and there's no question that the First Amendment applies. I think the harder set of questions is the set of questions that doesn't involve government compulsion, but involves Twitter or Facebook operating on their own.